Hey everyone, it's Rob Ryder. On January 22nd, 2014, that would be a Wednesday evening, real cold in Michigan, must be winter time. What we're looking at here is something that Bob in Arizona had sent to me, and first of all, what he's found is when he contacts his law library and says, hey, can you send me the annotated version of a particular statute, they send it to him by email. They send him all sorts of stuff by email. So you may want to keep that in mind, and there's a reason we want to look at the annotated version instead of the unannotated version. And it's because the annotated version has the read between the lines stuff. So basically, if you were to look online at Arizona Revised Statute 28-1561, you would see the following: that uniform traffic complaint form need not be sworn to if they contain a form of certification by the issuing officer in substance as follows. I hereby certify that I have reasonable grounds to believe and do believe that the person named herein committed the offense or civil violation described herein contrary to law. A. And then B is a false certification under this provision of subsection A is perjury. Right? So if there's a if you certify other than this, falsely, perjury. All right, so that's what we're going to be looking at. So that's what you would see online. Before we go any further, where was this thing? I noticed this. It says ARS 28-1561, which is what you would find online, Arizona Revised Statutes. Go to the legislative website, put it in, boom, find it. But what is AZST 28-1561? It's a different book of some kind. Don't know what it is. Anybody know what AZST stands for? Please send me an email. My email is courtofrecord@aol.com. Okay, so that's what the statute says. And then after that it has things that may have happened in court cases that would enlighten us more about what they meant by this. We're going to get into that in a second. Certification, enacted legislation, right? And what's Chapter 76 SS6? Because we have public acts, and we have revised statutes, and we have compiled laws, and we have session laws, and so forth and so on. What is CH 76 subsection 6, effective October 1st, 1997? Some kind of legislation. What do they call that? Historical notes, what it's been formerly known as, yada, yada, yada. So you can get all sorts of interesting things that you don't get. Oh, and now some cites. Here's some court cases that had something to do with this form. So interesting things that we may be able to pick through and find some pieces we can use. That's what we're going to attempt to do right now. And I don't want to look at this whole thing because this is kind of hard for me to read, and I can't color it with my crayons the way I'd like to. So I just wanted to show you what the form looks like and why you may, in the future, want to contact your law library when you find a statute in your compiled laws or statutes, whatever, that you're interested in, and ask them to send you, if they could, a copy of the annotated version. So the thing about this is, okay, this is what it said, and we want to see what this notes of decisions were. Alright, so I'm going to get rid of this because it's taking up too much room on my computer, and go to, this is that note, Arizona Revised Statute Annotated. It said in that note, the uniform traffic complaint is nothing more than a citation to appear or a summons, and is not a warrant for arrest. So it's a notice to appear. That's what it is. It's not a warrant. Former section provided that traffic citation forms or traffic complaints need not be sworn to if they contain certification by the attesting officer that he had reasonable ground to believe and did believe that offense had been committed by a person cited is merely directive statute as to a part of the traffic complaint form and did not set up a new form of arrest for traffic violations separate and distinct from law of arrest for all other misdemeanors, and did not validate arrest without warrant for alleged misdemeanor of driving or being in actual possession of automobile while under the influence of intoxicating liquor where alleged offense did not take place in presence of arresting officer. That's what that note was. Well, what did this say? Well, it said that first of all, the complaint is just a promise to appear. You haven't been charged with anything. It's not a warrant for your arrest. Although you've been arrested, there's no warrant. It's a warrantless arrest. But this form is just a promise to appear. And that if it has this particular certification that he has reasonable grounds to believe and did believe that offense has been committed, right? But even if it had that, it did not set up a new form of arrest for traffic violation separate from distinct from law of arrest of all other misdemeanors. Well, normally if there's a misdemeanor, right, there has to have been a complaint to say that you broke the law, and that complaint needs to be sworn before a magistrate. And then they issue a warrant and they, you've been arrested. And the warrant has to actually, if I'm not mistaken, has to be signed off by two justices of the peace, the hearing officer and then the judge. Got to have two signatures on it and a court seal. So eventually I'll get to it. This here is there's all sorts of things we're going to talk about in this form. Arizona traffic ticket and complaint. This is like a universal, uniform traffic ticket. And it calls itself a complaint. It says right on it, it's a complaint, right? It says that there at the bottom, Arizona traffic ticket and complaint. It says it's a complaint. And it has a place on here where the guy's going to certify. Of course, you've been following me. You've seen this before. This isn't the first time we talked about it. Hopefully one of these days will be the last time we talk about it. But today we're going to talk about it again. Because we got stuff. So what's it say? It says, I certify that upon reasonable grounds, I believe the defendant committed the above violations, and I have served a copy of the complaint upon the defendant. Well, he didn't call it a notice to appear. All right, so let's go back to this thing here. Right, he didn't call it a notice to appear or a summons. He called it a complaint. Well, that was different than a summons or a notice. And what he didn't say is that he has reasonable grounds to believe and did believe. Right? That's what it's supposed to say. And it says on here, I certify that upon reasonable grounds, I believe. Okay, upon reasonable grounds. Well, I certify that upon reasonable grounds. Well, whose? Upon whose reasonable grounds? Right? He didn't. In other words, this little statement here is not what the court said it has to be. That he had reasonable grounds. Right? I certify I have reasonable grounds and I believe. Would have been more proper. But beyond that, he's saying that he served a copy of the complaint upon the defendant. And this says it's nothing more than a citation to appear or a summons. All right, well, neither of those are the complaint. Those are the things that you get that goes with the complaint, but they're not the complaint. All right, so there's been no complaint yet, right? So then this officer would have to go finish up whatever the law says you do with misdemeanors. Well, that's kind of right here. So again, is that a false certification? Well, if it is, it's perjury. But here's what we have about a complaint. A complaint may be laid before a magistrate that a person has threatened to commit an offense against a person or property of another. Examination of complainant, issuance of summons or warrant of arrest. When the complaint is laid before the magistrate, he shall examine on oath the complainant, that would be the officer, and any witness he produces. And if there is just reason to believe that the commission of the offense threatened by the person complained of is imminent, the magistrate shall issue a summons or warrant of arrest, reciting the substance of the complaint. If a warrant of arrest is issued, it shall command the officer to forthwith arrest the person complained of and bring him before the magistrates. Complaints stating misdemeanor charges laid before a magistrate under the provisions of some other section or filed with the magistrate under some other section need not be sworn to if they contain a form of certification by the arresting officer in the substance of, and we've read it before, I hereby certify that I have reasonable grounds to believe and do believe that the person cited herein committed the offenses described herein, contrary to law. And you don't have anything here about being contrary to law. What we have is that he served a complaint. It calls itself a complaint. This says it's not a complaint. It's just a frickin' citation to appear or a summons. That's like a simulated legal process. It's got a false certification under such provisions of subsection A of this section shall constitute perjury. Officer committed perjury. Arrest without warrant. A person arrested without warrant shall. So this is this 1398 that up here. Where are you? 1389. Arrest without warrant. A person arrested without warrant shall, without unnecessary delay, be taken before the nearest or most accessible magistrate. Right? Because they said this isn't a warrant, so now you're supposed to be taken before a magistrate in the county in which the arrest occurred, and the complaint shall be made before the magistrate, setting forth the facts and basis of his statement of facts showing the offenses which the person was arrested. So again, the complaint and the complainant will go before the magistrate, and under oath, the complainant will tell a story. The provisions of subsection A shall not apply where the person making the arrest is a peace officer and decides to proceed under the provisions of 13903, and 13903 says notice to appear and complaint. Well, what did we see here? That again, this is saying that this form is nothing more than a citation to appear, a notice to appear. There still needs to be a complaint. In any case in which a person is arrested for a misdemeanor offense of petty offense, the arresting officer may release the arrested person from custody in lieu of taking the person to a law enforcement facility by use of the procedure prescribed in this section. At any time after taking the person arrested for a misdemeanor offense or petty offense to a law enforcement facility, the arresting officer, instead of taking the person to the magistrate, may release the person from further custody by use of the procedure prescribed in this section. Right? So they could just let you go by the side of the road, or they can put the cuffs on you, let you sit there for a bit while they do a little paperwork, nice and hot in the back of the car. Cuffs are a little bit too tight. Hands start to turn purple. Been there, done that. And then they'll go drive you down to the law enforcement facility and let you sit there for a bit. And then they come and say, well, I'm going to do this, and release you, right? And you're just glad to be gone. You say thank you very much, and you take your lick and leave, and hopefully for them you've learned your lesson. That's enough that you'll just be a good little slave and come back and pay your dues. That's what they'd like. Well, we're kind of tired of doing that. Okay, so they could either just release you on the side. Either way, you've been arrested. In any case in which a person is arrested for a misdemeanor, right, they can let you go, or they can take you to the law enforcement and let you go. Either way, without seeing the magistrate. If a person arrested for a misdemeanor offense or petty offense, and offense listed in some other section, subsection C, the person shall not be released pursuant to, unless they've been fingerprinted. The arresting agency shall provide the arresting person a mandatory fingerprint. So in here they got some shit that if you've been arrested for that, you're going to be fingerprinted before you can leave. In any case in which a person is arrested for a misdemeanor offense of petty offense, the arresting officer may prepare in quadruplicate a written notice to appear and a complaint containing the name and address of the person, the offense charged, and the name and place where and when the person shall appear in court. And again, this says that this form, even though it says it's a complaint, is merely a summons. So they haven't given you one yet. It's just a notice to appear. Specifying the notice shall be the court specified in the section. Right? Because really, that's the kind of stuff that would be on a notice. The complaint wouldn't tell you what court to go to and stuff. And when they get all done, they're going to put in right in here, insert the place of appearance, title and name of court, judge, juvenile, referee, yada, yada, yada. They're going to put all that stuff in there. The arrested person, in order to secure release as provided in this section, shall give his written promise so to appear in court by signing at least one copy of the written notice and complaint prepared by the arresting officer. The officer shall deliver a copy of the notice and complaint to the person promising to appear. So they're trying to say that this form is both a notice and a complaint. This guy just said it's a complaint. I served a copy of the complaint. He didn't say it was a notice. Doesn't say on here anywhere it's a notice. It says it's a complaint. The officer, as practical, shall deliver the original notice and complaint to the magistrate specified therein. Thereupon, the magistrate shall promptly file the notice and complaint and enter it into the docket of the court. The Arizona traffic ticket and complaint may be utilized not only for the purpose of providing Arizona Supreme Court rule, but to satisfy requirements of this section. When a person has given his written promise to appear in court upon designated date pursuant to the section and thereafter fails to appear, personally or by counsel, or on or before that date, the court clerk or other court staff shall file a complaint in writing under oath setting forth the offenses of knowingly violation of the written promise to appear in accordance with some section. So understand that because this says it's not a warrant for your arrest, you've not really been arrested. It's not the complaint, it's just a summons, so forth, that, regardless of what they say it is, that it's a complaint. When you sign this name here, you're going to say, without admitting guilt, I promise to appear as directed hereon. Without admitting responsibility, I acknowledge receipt of this complaint. Right? Again, it's a complaint. It's not a notice. But you're giving your promise to appear. Well, if you don't follow through now, even though it really wasn't a complaint, and you haven't really been charged anything because there's no complaint to charge you, right? It's not gone before the magistrate. Nobody swore anything under oath. What the hell are you going to court for? You've been arrested, but, well, and then what they're going to do, because of this little section F here, right? So now when you walk in, this is where they're going to try to get you in the hallway, and the prosecutor's going to try to cut a deal with you. And sit there and talk and yak and yak and yak, and you think you're sitting in the courtroom you're supposed to, and I don't believe that's where you're supposed to be. That's the administrative side of the court. You were supposed to go find the court administrator, appear to them. The hearing officer, appear to him. Violation of promise to appear. Any person knowingly violating his written promise to appear, given as provided in this article, is guilty of a Class 2 misdemeanor. Right, boom. So now you're going to be guilty. Now you will be guilty of a misdemeanor because you broke your promise. So what is it they're doing, actually? Well, if this says it's a summons, this says it's a complaint, and this says it gave you a complaint, and you're signing saying it's a complaint, that's a simulated legal process. My opinion, right? They're guilty of a simulated legal process. A person commits a simulated legal process if such person knowingly sends or delivers to another any document falsely purporting to be an order or other document that simulates civil or criminal process. And if it isn't a complaint and it says it's a complaint, then it's simulating a legal process. And a little bit of stuff on perjury. Now, the thing is, this form here, this is the Arizona traffic. What do they call this thing? Traffic ticket and complaint, ATTC. Agencies must complete request to approve a substantial variation in the ATTC form for consideration of any proposed substantial variations in the Arizona traffic ticket and complaint form. A citation is considered substantially different and will require approval by the Supreme Court if it deviates from the ATTC form provided for in Arizona Arizona Rules of Court, Rules of Procedure, Traffic Case, Voting Case, Appendix A. Okay, when I went to the traffic site, or the judicial site for Arizona, this is the form that shows up, this one that we've been talking about right here. Alright, so I guess if they want to do, anything to this form other than what's on here, they have to get their approval. Zoom. Well, right off the bat, the form they're giving them it isn't a complaint, and that's what they're using it as a complaint. It says it's a complaint, it's not a complaint. It says it's a complaint, original complaint, in red, says it's an original complaint. No, it's a notice. This said it's a frickin' summons or a notice. Okay. 28.15.56. So this section here, because the particular annotated law we looked at was 28.15.61. So this is the section that goes with that. This has got a lot of interesting things in it also. So applicability of procedure, arrest without warrant. Sections, get some other sections. Govern all police officers in making arrests without warrant for violations of Chapter 3 or 4 of this title and this chapter. The procedure prescribed in this article is not exclusive of any other method prescribed by law for the arrest and prosecution of persons for the offense of like grade. Now, let's just take a quick look. So here's these other sections that it's talking about here. 1551 to 1554, 1551, yeah, we're going to be looking at those. 1524, for instance, 1524. It's a Class 2 misdemeanor for the owner or other person employing or otherwise directing the driver of a vehicle to require or knowingly permit the operator of the vehicle on the highway in any manner contrary to law. All right, so that's one of them. Okay. For a criminal offense alleged to have been committed in violation of this title and for which the officer is not authorized to arrest without a warrant, the officer may present the alleged violation before a magistrate in the same manner as any other misdemeanor, what they're supposed to do, and may proceed either under warrant of arrest or a summons and notice to appear. So again, the form, the traffic ticket form, this ATTC form, according to the courts, is nothing more than the notice. Well, then he still has to, the officer may present the alleged violations before a magistrate in the same manner as other misdemeanors, which means go swear out a complaint. He ain't done that. He's just done a summons and notice to appear. Each traffic enforcement agency of the state shall use the uniform traffic ticket and complaint form for traffic complaints pursuant to the rules and procedures of traffic cases adopted by the Supreme Court of Arizona. That is issued in books meeting the requirements of this article. Now, pay attention. Each traffic complaint shall contain the following notice. Because first of all, it says they're all going to use the each traffic enforcement agency, uniform traffic ticket and complaint form, right? The ATTC form. Each traffic complaint shall contain the following notice. If you fail to appear as directed in this complaint on a criminal charge, a warrant will be issued for your arrest and your license will be suspended. 2. If you fail to appear as directed in this complaint on a civil traffic violation, a default judgment will be entered against you, a civil penalty will be imposed, your license or non-resident operating privilege will be suspended until the civil penalty is paid. Right? That has to be on the form. Well, I've looked on this form all day long, and I don't see where it says that. All right? Unless it's on the back of the form, and I don't have the back to look at. I don't know, but it's not on the front. It's not on this form, and this is the form off of the judicial website, and it ain't got anything near what the law says it has to have. Right? So again, it's a simulated legal process. The frickin' form itself is a simulated legal process. Now the interesting thing, and now is a good time to go look at this other one. Let's go look at this. Parties to a crime. A person who commits, attempts to commit, conspires to commit, or aids or abets in the commission of an act declared in Chapter 3 or 4 of this article, of this title or this chapter to be a crime, whether individually in connection with, is guilty of the offense. Okay. A person who falsely, fraudulently, forcibly, or willfully induces, causes, coerces, requires, permits, or directs another person to violate any provision of Chapter 3 or 4 of this title is guilty of the offense. They're guilty of perjury. They're falsely, fraudulently, forcibly, willfully inducing, coercing, all sorts of violations, because they're telling you that this is a complaint, but it's not a complaint. It will be a promise to appear. That's all it is a promise to appear. It's not the complaint. Right? They're simulating a legal process. It has to. This says it has to have these on there. 28, 15, 57 shall contain the following notice, 1 and 2. The Chief Administrative Officer. Now, who's the Chief Administrative Officer in each traffic enforcement agency? That would sound like the court administrator, would be my guess. Or if it's a traffic enforcement agency, could that be like the Chief of Police? I guess it depends on what a traffic enforcement agency is. Responsible for the issuance of the books. So, going to have to call and ask them. Shall maintain a record of every book and each complaint contained in the book issued to individual members of the traffic enforcement agency. See, they haven't called it a complaint. Shall require and retain a receipt for each book issued. Traffic complaint that is issued to the individual shall not contain a person's social security number, yada, yada, yada. Traffic complaints, disposal of records. On issuing a traffic complaint to the alleged violator of any provision of the motor vehicle laws, traffic ordinance, city, town, each traffic enforcement officer shall deposit the original or copy of the traffic citation with a court having jurisdiction over the alleged offense or with its traffic violation bureau. Right? So either with the court or the traffic violation bureau. On the deposit of the original or the copy of the traffic complaint with the court having jurisdiction of the alleged offense, the traffic violation bureau, the original or copy of the traffic complaint may be disposed of only by trial in court or by other official action or by judge of the court of the hearing officer. Once it goes in the bin, it ain't coming back out. Right? It's either going to be in the trial or other official action by a judge of the court or the hearing officer. It is unlawful and official misconduct for any traffic enforcement officer or other officer or public employee to dispose of a traffic complaint or complaints of a traffic complaint or copies of a traffic complaint or of the record of the issuance of the complaint or copies in manner other than required by this article. The Chief Administrative Officer of each traffic enforcement agency shall require the return to the Chief Administrative Officer, to him. So who's the Chief Administrative Officer? Chief Administrative Officer is the CEO, Chief Executive Officer. And that's the court administrator in a lot of places. Could be the court clerk. Have to ask. A copy of each traffic complaint issued by the officer under the Chief Administrative Officer's supervision to an alleged violator of any traffic law or ordinance. That makes it sound like it's a chief of police. All copies of each traffic complaint that is spoiled, yada, yada, yada. Traffic case records, each magistrate, judge, or hearing officer of court shall keep or cause to be kept a record of each traffic complaint or other legal form of traffic charge deposited with or presented to the court or its traffic violation bureau. So I guess you would go to the court and ask if they have a traffic violation bureau and have a talk with the hearing officer and say, hey, they're not following the law. This was merely a promise to appear. Keep a record of each official action by the court or its traffic violations. Amount of civil penalty. Okay, immediately. Okay, the amount. Where are we at here? 28-15-59. Each conviction, forfeiture, bail, deposit, judgment, or acquittal of a civil adjudication. The amount of the civil penalty, fine, forfeiture, so forth and so on. Within 10 days after conviction, judgment of forfeiture, bail, or deposit. This chapter, other law regulating the operation of vehicles, each magistrate of the court or clerk of the court of record in which the conviction or judgment was had, or bail or deposit was forfeited, shall prepare and immediately forward to the department an abstract of the record of the court covering the case in which the person either was convicted or was adjudicated to have committed a civil traffic violation. Now, what's the difference between being convicted and adjudicated? There has to be a difference, or they wouldn't have used them both. I think adjudicated is, right, they're going to get you to agree you committed the crime, and then they can go ahead and say, yeah, he confessed. Really, that's what the attorney's trying to get you to do. The cop is out there getting you to promise to appear, and the attorney, before you get to court, to the place you're supposed to go to say, hey, what's this all about? I'm appearing, is going to get you to self-confess to something. A person required to prepare the abstract shall certify that it is true and correct. So it'd be interesting to see one of these abstracts, because they have to, within 10 days of you being convicted or whatever, they have to prepare an abstract and send it somewhere, and that should be a public record. Where's this abstract they're talking about? Abstract shall be made in a form furnished in a manner prescribed by the department and shall include the name and address of the party charged. That's interesting. The name and address of the party charged. See, we may get some information we're looking for, like what's our address they're charging us on. The number, if any, of the driver's license of the party charged. The registration number of the vehicle. When they ask you license, registration, and insurance, they could be asking you for your certificate of title, which is the registration number of the vehicle. In my opinion, the nature of the offense, the civil or civil traffic violation. Okay, so all sorts of crazy stuff they're asking for. A person, 1560, illegal cancellation of a traffic citation. A person who cancels any traffic citation in any manner other than as provided in this chapter of the Non-Residential Violator Compact, adopted by Chapter 6, is guilty of a Class 3 misdemeanor. The appropriate fiscal officer of the governmental agency to which the traffic enforcement agency is responsible shall audit monthly the records of the traffic citations required in this article. Who's the appropriate fiscal officer? That should be the court administrator. They were the fiscal officer from the research we did last few weeks. Certification of uniform traffic complaint forms. A uniform traffic complaint form need not be sworn to if they contain a form of certification by the issuing officer in substance as follows. I hereby certify that I have reasonable grounds to believe and do believe that the person named herein committed the offense or civil violation described herein contrary to law. A false certification under the provision of the subsection A is perjury, and when we go look at their form, we look at what it says. I certify that upon reasonable grounds, I believe the defendant committed the above violations, and I have served a copy of the complaint upon the defendant. Alright, they don't say anything here about being a defendant. I certify I have reasonable grounds to believe, and do believe, that the person named herein committed the offense. Don't say anything about being a defendant. How do they make you the defendant already? They made you a defendant and they said it was a complaint. Yet the court said it's just a summons. They got some, they got some shit to answer for. Where's the sworn complaint? Well, that's the point. Once they drop this in the box, they've made their play, and now it's up to us to go in and say, let's go check the record, and I want the court to take judicial notice of its own record. All right, they're going to deposit the original. Okay, there's the citation, which the court has said is a summons, notice to appear, I'm here. Where's the sworn complaint? Right? You can't charge me for a crime unless you're going to swear out a complaint. Where's the sworn complaint? And by the way, the form he put on that he used, it doesn't have this, like the court said it needs to say. So I believe they're simulating a legal process. I believe somebody's committed perjury. I believe you got some work to do, court administrator. I want to put in a complaint about this court case. And so that's what we're going to find out. Bob's got reason to go do one. So, all right, Bob in Arizona, there you go. That was for you. More stuff. How many more things we got to point out? I don't think we need to point out any more. Do we cover all these here? Let's see. Municipal courts and justice courts have concurrent jurisdiction over all things within their jurisdiction, within their boundaries. Okay, so municipal and justice courts have concurrent jurisdiction over all civil violations. Subject to funding by a government body and within their jurisdiction, justice courts may appoint hearing officers to preside over civil violation cases. All right, so when you go into court, the guy sitting there isn't necessarily the judge, he's a hearing officer. You're in a hearing. You're not necessarily in a court case yet. You're not in a trial. And the city or town, which would be a municipality, may appoint hearing officers also. The judgment of the hearing officer constitutes the judgment of the court and may be appealed to the Superior Court pursuant to Title 22, Chapter 2, Article 4. So hearing officers may hear and dispose of civil traffic violation cases under the supervision of the court. All right, so the court can take superintending control. You're not in the court yet. You're just in a hearing officer with a hearing. And they're under the supervision of the court, but the court isn't there, so the court doesn't see this indirect contempt of court that's going on, and you need to go point it out. Or you could appeal it, but I would go in and just, well, I guess I got to go read this Title 22, Chapter 2, Article 4, which I haven't done yet. Nevertheless, I'm going to go in to the court where it happened, talk to the court administrator, and tell them I believe there's contempt of court. And who do I bring my ex parte motion and affidavit of fact to have you investigate for contempt of court? Okay, let's hope that's the last time we got to look at this form. Until somebody has actually gone and done something with it. Right down to the end. Because this thing is not anything like what the law says it's supposed to be. It doesn't have each traffic complaint shall contain the following notice. I don't see them notices on there. 28-15-57. Arizona Revised Statute. 28-15-57. Says it has to have them on there. And they ain't on there. So you go into that court administrator and say, well, according to Arizona Revised Statute 28-15-57, it says that these complaints have to have these statements on there. And they don't have those on there. And that would mean that according to 132814, that you're simulating a legal process. Falsely purporting to be an order or other document that simulates civil or criminal process. It's a Class 2 misdemeanor. Certificate's incorrect. That's perjury. Let them go figure out who's going to jail, right? But get them to get you off the hook. Okay. Y'all have a great night.